Hello and welcome everyone to the Drishti IAS English YouTube channel. I am Pragya with you today. As you all are aware, we are running two new series, that is the Target UPSC Prelims 2024 Current Affairs series and MCQs practice series as well, so as to help you in your preparation. In the previous episode of Polity, we were discussing the Winter Session Acts, and in today's episode, we will be discussing the remaining legislations that were enacted in the year 2023. The legislations which we are going to discuss today include the Model Prisons Act of 2023, the Panchayats, extension to the Scheduled Areas Act 1996, also known as the PESA Act, okay, then Women Reservation Act of 2023, Press and Registration of Periodicals Act of 2023, then the Lokpal and Lokayuktas Act and the Right to Information Act of 2005. Let us begin our discussion today by discussing the very first legislation, that is the Model Prisons Act of 2023. As you all are aware, prisons reforms are quite necessary in India. We have a huge number of under trials. We have a huge pendency of cases. The conditions of prisons are not good, especially for women prisoners. We do not have dedicated prisons for women prisoners, okay? And that is why the government thought of enacting a new legislation so as to enable reforms in the prison administration in India. So let us discuss why this act is in news. Recently, the Ministry of Home Affairs has drafted the Model Prisons Act of 2023 to replace the outdated Prisons Act of 1894. So this Prisons Act of 1894 is an old and archaic law that was responsible for prison administration in India. But what was the problem? That due to the changing times, this law was not changing itself, and then it did not believe in the concept of reformation and rehabilitation. So it did not believe in the concept of reformation of inmates or rehabilitation of inmates, and that is why this old and archaic law had to be replaced, and that is why the government of India enacted the Model Prisons Act of 2023. This new legislation aims to modernize prison administration with a focus on rehabilitating and reformation of inmates. Now, what are the key provisions of this act? Let us discuss. So, if I talk about the key provisions, punishments outlined for prisoners and jail staff caught using prohibited items like mobile phone within prison premises. Then, introduction and management of high security and open jails, including both open and semi-open facilities. So, the concept of open jails has been finally introduced in India. Then, measures to safeguard society from criminal activities of repeated offenders and hardened criminals. So, where exactly is this subject of prison and persons living in these prisons included? It is included in entry 4 of list 2 of 7th schedule of our Indian Constitution. That means it is a state subject. Prisons and persons living in the prisons is a state subject. The state has the power to make laws on this subject. Moving forward, provision of legal aid, parole, furlough and early release to encourage good behavior among inmates. Then implementation of security assessments, individualized sentence planning and grievance redressal mechanisms. Establishment of a prison development board, and this authority will be first such kind of authority that will be established in India, and initiatives to promote attitudinal change towards prisoners, including separate accommodation for women and transgender inmates. And this was very much required because women were suffering in the prison. They were suffering from sexual abuse, they used to get pregnant, etc., and all of these issues were very common, and that is why we needed dedicated prisons for women and transgender prisoners, okay. and this has finally been introduced by the Model Prisons Act of 2023. Incorporation of technology to enhance transparency in prison administration, including video conferencing with courts and technological interventions, and these will definitely help to reduce the pendency of cases and will bring more justice to the under trial prisoners in India who are rotting in the jail because they are still not being tried in the courts. Okay, the judgment is still not delivered and they are not even getting bail, and that is why our prisons were very overcrowded in nature. And due to the video conferencing facility, due to the technological initiatives, definitely it will serve justice to the under trial prisoners in India. Moving forward, let us discuss some of the other initiatives related to the prison reforms in India. So, modernizations of prison scheme 2002 to 2003. It was launched to improve the condition of prisons, prisoners and prison personnel. Then modernization of prisons project that will be running from the year 2021 to the year 2026. That means this project is already in existence, and it aims to provide financial assistance to states and union territories for enhancing jail security and implementing correctional administration programs for prisoner reformation and rehabilitation. Then e-prisons project, it seeks to introduce efficiency in prison management through digitization. Moving forward, Model Prison Manual 2016, it provides a comprehensive information about legal services, including free services available to the prison inmates. As you all are aware that right to free legal aid, is a fundamental right under Article 21 of our Indian Constitution. As per the Code of Criminal Procedure as well, whenever there is a court of session trial and the court of session feels that the accused is not being represented due to any kind of constraint, he is not capable of hiring a defense lawyer, then the court of session will provide a defense lawyer to such kind of accused person at the expenses of the state. And that is why this free legal aid provision becomes very, very important. We also have the National Legal Services Authority, or the NALSA, which was established under the Legal Services Authorities Act 1987 to ensure the provision of free and competent legal services to the weaker sections of the society who were not able to secure the ends of justice because they were not able to afford the fees, or there were financial constraints and there were other issues as well. So, to overcome all of these problems, we constituted the National Legal Services Authority. Moving forward, let us discuss the Panchayats extension to the Scheduled Areas Act of 1996, or the PESA Act of 1996. So, what is the aim of this PESA Act of 1996? It aims to extend Part 9 of our Indian Constitution to the scheduled and tribal areas. Scheduled and tribal areas. So, it aims to enhance self-governance among the tribal people, especially the extension of panchayats to the scheduled and tribal areas. Now, let us discuss why this legislation was in the news. So, recently the Jharkhand has released the draft rules of the Panchayats extension to the Scheduled Areas Act, or the PESA Act, for public consultations. Moving forward, let us discuss about this act. So, it was established in the year 1996 based on the recommendations from the Dilip Singh Bhuria Committee to empower tribal communities and integrate them into the mainstream. Okay, so if you'll ask me, ma'am, how are the rights of tribal people protected under the Indian Constitution? So, firstly, major tribes in India, Major tribes in India are collectively known as scheduled tribes in Article 342, Clause 1 and Clause 2. Then we have Part 10 of the Indian Constitution. Part 10 of the Indian Constitution, which talks about the administration of scheduled and tribal areas, and this has Article 244. Then we have the 5th and 6th schedule. 5th and 6th schedule. Then we also have the provisions of PESA Act and the Forest Rights Act of 2006. And all of these provisions are aimed at securing tribal rights in the India. If you talk about the PESA Act, it is often referred to as a constitution within the constitution due to its unique provisions and focus on tribal empowerment. Moving forward, let us discuss the constitutional basis. So basically, as I said, it extends the provision of Part 9 of our Indian Constitution concerning panchayats to the scheduled areas of 10 states under Article 244, Clause 1 in conjunction with Schedule 5 with modification and exceptions. It also empowers the state legislatures to enact laws in this context. And what is the nodal ministry? It is the Ministry of Panchayati Raj. Moving forward, let us discuss the key provisions of the PESA Act of 1996. So, conformity with customary law, state legislation regarding panchayats must align with the customary law, social and religious practices and traditional management practices of community resources. See, if you talk about the tribal community in India, it is not very modernized. It is still not connected with the world today. It has its own custom, and most of them are not even Hindus. They do not identify themselves as Hindus, okay. They have their own customs, they have their own traditions, and therefore it is very necessary that we preserve this unique custom and culture of the tribal communities in India. Then Gram Sabha. Each village is mandated to have a Gram Sabha composed of individuals listed in the electoral rolls for the village level panchayat. Moving forward, role and responsibilities of Gram Sabha. So, the Gram Sabha holds authority in approving all development projects within the village, identifying beneficiary and issuing certificates for fund utilization. So, which authority is responsible for administration if panchayats exist in the tribal areas, if panchayati system extends to the scheduled and tribal areas, it will be the Gram Sabha. So, Gram Sabha is very powerful in this regard. It plays various roles and it has various responsibilities in this regard. It also possesses power to oversee institutions and functionaries across various social sector and local plans. It ensures the preservation of traditions, customs, cultural identity, community resources and customary dispute resolution methods. So, the nodal authority is the Gram Sabha, and in this case it is very powerful in nature. It has various roles and responsibility to play. Moving forward to the reservation. So, reservation of seats within every panchayat is required proportionate to the community's population with a minimum reservation of 50%. The chairperson position at all panchayat levels is reserved for the scheduled tribes. So, basically it gives a huge amount of reservation to the tribal communities. Moving forward, let us discuss another legislation of our today's discussion, and this is the most famous Women's Reservation Act of 2023. So, as I have taught you that the 106th Constitutional Amendment, 106th Constitutional Amendment Act of 2023 also known as the Nari Shakti Vandan Adhiniyam, has granted 33% reservation to the women in Lok Sabha, State Legislative Assembly and the Legislative Assembly of Delhi. So if you'll ask me, ma'am, why this topic is in news, due to the 106th constitutional amendment, and it aims to provide 1/3 reservation to women in the Lok Sabha, State Legislative Assembly and the Legislative Assembly of National Capital Territory of Delhi. Okay, the background, the bill was previously introduced in the year 1996, 1998, 2009, 2010 and 2014. Okay, then articles inserted, article 330A, 332A. Then there were changes in the article 239 clause AA as well. And its sole aim is to provide reservation to women so that they can enter politics. Moving forward, let us discuss the key provisions. As I said that yes, it introduces reservation for the women. Okay. Then provision for rotating reserve seats for women among different constituency within states or union territory. Proposal to reserve 1/3 seats within SC/STs reserve seats in rotational manner for women. So most of you were asking me that is women reservation only for the SC/ST category? No, it applies to the general category as well. And that is why we say that it has introduced quota within quota. So out of this 33%, 1/3 seat, 1/3 seat is reserved for women belonging to the SC and ST community, and Parliament has the power to rotate these kind of seats in specific constituencies. Okay, moving forward, introduction of article 332A mandating reservation for seats for women in every state's legislative assembly. Then requirement to allocate 1/3 of SC/STs reserve seats for women, as I said. Then mandate to reserve 1/3 of total seats filled through direct elections in the legislative assemblies for women. Moving forward, commencement of reservation, that is article 334 clause A of our Indian constitution. So reservation to commence after publication of census conducted post the bill's enactment. Delimitation to reserve seats for women based on census data, and reservation to be effective for 15 years, extendable as determined by the Parliament. And this provision is being criticized by the various critics, saying that you are not conducting the census, you are not conducting any kind of delimitation exercise. So when are you exactly planning to implement the women reservation? Definitely they are not being implemented in the upcoming general elections. So the opposition was asking this question, that when exactly are you planning to implement this legislation? Moving forward, reservation for women in the National Capital Territory of Delhi. New clauses have been inserted in article 239 clause AA, and amendment to this article to grant special status to Delhi as national capital, with laws framed by Parliament applying to it. Then rotation of seats, rotation of reserve seats for women after each delimitation, regulated by Parliament's legislation. So not only it provides reservation to women in Lok Sabha, State Legislative Assembly, it also provides reservation to women in the Legislative Assembly of the NCT of Delhi. We all know that article 239, that was inserted by the 69th Constitutional Amendment Act, has granted a special status to the National Capital Territory of Delhi. Moving forward, let us discuss the Press and Registration of Periodicals Act of 2023. And what is the nodal ministry? It is the Ministry of Information and Broadcasting. So why is this legislation in the news? So recently the Press and Registration of Periodicals Bill 2023 was approved by the Lok Sabha, replacing the outdated Press and Registration of Books Act of 1867. So slowly and steadily we are trying to change all of our archaic laws, all of our colonial era legislations, so as to make them applicable to the current scenario. What are the key provisions? So registration of periodicals, it facilitates registration of periodicals in online mode. And this is in tune with the digital India. And if you'll ask me, ma'am, what exactly are periodicals? So periodicals are any publication which includes newspapers. And it is compiled and printed at regular intervals. And it contains public news or comments on public news. Comments on public news. So this is the meaning of periodicals within the Act. And if you'll ask me the exceptions, these do not include books and journals, which are there for scientific, technical, and academic purposes. That means the books and journals which are there for scientific, technical, and academic purposes do not have this mandatory requirement of getting themselves registered online. So, as I said, it includes books and scientific and academic journals from registration, which falls under the jurisdiction of the Ministry of Human Resource and Development. So, what are the registration protocols? Periodical publishers can register online. The individuals convicted of terrorism are barred from publishing. Again, a very, very important provision. Then foreign periodicals. Reproducing foreign periodicals in India requires prior central government approval. Moving forward. And this Press Registrar General has replaced the Registrar of Newspapers in India. So this is also a very new body. Then printing press registration. Declarations regarding printing presses can be submitted online. And where you will submit all of these kind of registrations, okay. So you will submit it on the Press Seva portal. Which we will be discussing in our further slides. So, what is the suspension and cancellation provision? So, Press Registrar General can suspend or cancel registration for various reasons. And the penalties and appeals. So, penalties for unregistered publication or non-compliance and appeals available for refusal of registration or penalties imposed. Moving forward, let us discuss the Press Seva portal. It is an online portal for submitting various applications required under the new Act. It facilitates processes such as registration of periodicals, application for 𝐸𝐾𝐒 editions, transfer of ownership and submission of annual statements. So, all of this will enhance the digital India perspective. All of this will enhance accountability and transparency in the press and media domain. Moving forward. let us discuss the Lokpal and Lokayuktas Act. Very, very important piece of legislation. It is the anti-corruption ombudsman in India. So why it is in news? Recently, a high-level search committee has extended the date for receiving applications for the posts of chairperson and members of the anti-corruption ombudsman Lokpal. And if you'll ask me, ma'am, who is the current Lokpal chairman? So, retired Supreme Court Judge, Justice A.M. Khanvilkar is the current chairman of Lokayukt in India, Lokpal and Lokayukt. So, what are the key provisions? So, composition, it consists of a chairperson and up to 8 members. 50% must be judicial members and the remaining 50% from SC, ST, OBCs, minorities and women. What is the tenure of office? Chairperson and members serve a term of 5 years or until the age of 70, whichever is earlier. Moving forward to the selection committee. It appoints the chairperson and members and it is chaired by the Honorable Prime Minister of India. And it also includes the Lok Sabha Speaker, Leader of Opposition, CJI or nominee and an eminent jurist. And confiscation of property. It allows confiscation of property acquired through corrupt means even during pending prosecution. So, definitely it is in the anti-corruption ombudsman of India. And that is why they are not giving priority to this strict structure of Lokpal and Lokayuktas, because it has huge investigation powers. It can also exercise these powers very strictly in nature. Timelines for inquiry and investigation: 60 days for inquiry completion and 6 months for investigation by CBI. Lokpal can extend the investigation period upon written request from CBI. Power over CBI has superintendence and direction powers over any investigation agency, including CBI for cases referred by Lokpal. Transfer of CBI officers investigating Lokpal cases requires Lokpal approval. Removal: President removes Lokpal members after an inquiry by the Supreme Court, initiated by a petition signed by at least 100 MPs. And what is the jurisdiction? It extends to Prime Minister, ministers, MPs and various government officers. Okay, and it also includes societies, trust or bodies receiving foreign contributions over rupees 10 lakh. So, very, very important anti-corruption institution in India, and that is the Lokpal and Lokayuktas. Now, let us discuss the Right to Information Act of 2005. So, why is it in news as of now? Recently, the Supreme Court has instructed both the central and state governments to promptly fill the vacant position in the Central Information Commission and the State Information Commissions. Both play crucial roles in ensuring the effective implementation of the RTI Act and the protection of citizens' right to information. Moving forward, the genesis of the Right to Information law in India traces back to 1986, marked by a landmark Supreme Court judgment in the case of Mr. Kulwal versus Jaipur Municipal Corporation. And in this landmark judgment, the Supreme Court has held that right to information is a fundamental right under Article 19 of our Indian Constitution. So, basically it is covered by Article 19 clause 1 subclause A, and it is a very important fundamental right that is given to the Indian citizens. It has 4 purposes. Firstly, it ensures accountability and transparency. Accountability and transparency. It also contains corruption. It also helps in right to know. Because as per Thomas Jefferson, information is the crucial aspect of any kind of democracy, and it also helps in ensuring participation of citizens in democratic process. So these were the objectives of the Right to Information Act, and right to information is a fundamental right that has been granted to you by the Honorable Supreme Court of India through this landmark judgment under Article 19 Clause 1 Subclause A. Moving forward, let us understand the key provisions of this act. It mandates timely response to citizen requests for government information. The basic objective of the RTI Act is to empower citizens, promote transparency in the working of government, contain corruption and make democracy work for the people effectively, as I stated. Moving forward, this act has been amended in the year 2019 and it made significant changes to the original act. It altered the term of office of the CIC and SIC, okay, and the information commissioners, okay, giving the central government authority to prescribe their term instead of a 5-year term. And definitely this is going to hamper the independence of the CIC as well as the State Information Commission. Moving forward, the amendment also provided for the central government to determine the salary, allowances and other service conditions of the CIC and information commissioners. Provisions regarding deduction in salary due to pension or retirement benefits received for previous government service were removed for the CIC, state CIC and state SIC. That means the complete control of the CIC and SIC now lies with the central government. And definitely it is a huge blow to the transparency of the CIC and the SIC, and that is why the critics are criticizing the RTI Amendment Act of 2019. They are saying that they have a fixed term of 5 years, why have you removed? Why is the central government empowered to dictate their term? And that means they'll have to act in accordance with the central government, and this is the main criticism of the RTI Act of 2019. With this, we come to our conclusion of our today's discussion. We have seen the other major legislations that were enacted in the year 2023, and we have also discussed the key provisions of these legislations. I hope this session was insightful for you. If you have any feedback regarding this session, you can drop it in the comment box below. If you liked today's discussion and found it to be helpful, kindly like the video and subscribe to our channel for more such interesting updates. Till then, thanks for watching and keep revising with us so as to take your preparation to absolute new heights. Okay, thank you.
For more informative content, like, share and subscribe, and do not forget to press the bell icon to get the notifications.